Judgment in the appeal McGraddie against McGraddie and another.
Lord Reid will give the judgment.
This appeal raises a question as to the circumstances in which findings as to the credibility of witnesses made by the judge who saw and heard them give evidence can be reversed on appeal by a court which did not. The case concerns a family dispute. The pursuer is a man in his 70s who comes from Scotland but lived for many years in the United States. When his wife became terminally ill, they decided to return to Scotland. The pursuer asked one of his sons, the first offender, who is a property developer, to find a suitable property for him and his wife to live in. The first offender found a flat in Glasgow, and the pursuer put him in funds to buy it. The first offender made all the arrangements about the conveyancing and took title to the flat in his own name, without telling his father what he had done. About a year later, after the pursuer's wife had died, the pursuer gave the first offender a cheque for £285,000, which he used to buy a new house in Ayrshire. He again arranged the conveyancing and took title to the house in the joint names of himself and his partner, the second offender. According to the pursuer, however, the house was meant for himself. He had looked at the show house and reserved this house and had simply put his son in funds to make the arrangements. The pursuer then brought proceedings in which he maintained that the first offender had acted without his authority in taking title to the properties in his own name, or that of himself and his partner, and sought a conveyance of the properties. The defenders, for their part, maintained in their pleadings that the pursuer had instructed that title to the flat was to be taken in the first offender's name, and that the £285,000 had been a gift. The judge who heard the case believed the evidence of the pursuer on the central issues in the case and disbelieved the evidence of the defenders. Although he had reservations about some aspects of the evidence of all the principal witnesses, he considered that the pursuer gave his evidence in a manner which suggested that he was telling the truth and that the first offender did not. He also formed the impression that the pursuer was not a particularly generous man and that the first offender was someone who attached little importance to the pursuer's wishes and lacked a normal ability to grasp the import of conversations. He disbelieved the second offender because aspects of her evidence were inconsistent with an earlier account or were demonstrably unreliable. The judge concluded that the first offender had acted in breach of trust and that the properties should be made over to the pursuer. On appeal, there was no challenge to the judge's finding in relation to the purchase of a flat. In relation to the purchase of the house, however, the appeal court, the inner house of the Court of Session, decided that the judge had gone wrong because he had at one point in his judgment said that he did not find any of the other evidence materially to undermine the pursuer's account. The judges in the inner house identified a number of aspects of the evidence which undermined the pursuer's account. To give one example, it was not clear why he would have employed the first offender to arrange the purchase of the house when he appeared to be capable of doing it himself. On that basis, the judges decided that they were entitled to reassess the evidence for themselves on the basis of a written transcript. Since the aspects of the evidence which undermined the pursuer's account also supported the defender's evidence, they concluded that the pursuer's claim to the house should be rejected and that the defenders were entitled to keep it. The pursuer appeals against that decision to the Supreme Court. The Supreme Court unanimously allows the appeal for reasons set out in a judgment given by myself with which the other members of the court agree. The court's reasoning is based on principles which were authoritatively established in Scots law almost 100 years ago and are equally well established in the law of other comparable systems. According to those principles, the assessment of the credibility of witnesses is a matter for the judge who saw and heard them give evidence and who sat through the entire case and was totally familiar with every aspect of it. It is only on the rarest occasions that an appellate court is justified in finding that his assessment was wrong. In the present case, the reasons given by the inner house for overturning the judge's assessment were unsatisfactory. Some of the points which they regarded as undermining the pursuer's account did not in fact do so. The other points were all expressly taken into account by the judge when he concluded that he nevertheless believed the pursuer on the central question and disbelieved the defenders. Furthermore, the judges of Vienna House appear to have disregarded other aspects of the evidence which tended to point towards the truth of the pursuer's account. For example, the judge's assessment of the manner in which the witnesses gave their evidence, his assessment of the characters of the pursuer and of the first offender, the unchallenged finding that the first offender acted in breach of trust when purchasing the flat, and the various aspects of the evidence which undermined the defender's account. The court considers that this case illustrates two general points. The first is that appeals by their nature focus narrowly on particular issues. When deciding what conclusions can be drawn from evidence, however, it is essential to view the case as a whole. The second point is that the general principle that the assessment of credibility is preeminently a matter for the judge who saw and heard the witnesses should not be subverted by a narrow textual analysis of the judgment which enables the appellate court to claim that the judge went plainly wrong.